Number 94, People versus Lashway. Counsel, you want any rebuttal time?
Yes, please. Thank you very much. 2 minutes, if that's possible. If that's possible.
Go ahead, Counsel. Sure.
May it please the Court, my name is Marcy Flores, and I represent Stephen Lashway in this matter. I think that Mr. Ivanovich and I agree that there are only 2 documents that are missing that was not provided to my client for discovery, and it was from the Department of Parole and from the Attorney General's office. All the other documents were received. It is our contention that my client should have been granted an adjournment so that he could get those documents.
Didn't you know that those documents were not in the file before you got to the hearing?
In terms of whatever the documents that the prior attorney had, she had, I was not given them from her, or she did not give them to me. I only have what was in the record. So, yes, it's possible that she would have not have known about it, but she did request through an order to show cause to get all the documents. And as soon as the letter came in, which is July 27th, indicating the documents are not there, that's, she realized they weren't there, and it indicated it would take a few weeks to get those documents. They were in storage. So, therefore, she legitimately, in my opinion, requested an adjournment on the day of the hearing so that she could get the missing documents, because it is the burden of proof is on the defendant. As opposed to what my client said in the record, we all understand that the burden of proof is on the attorney, my client's attorney, to go forward with the modification.
What's the practical consequence? Your client is not out on the street.
I understand that.
What's the consequence of the
believe
lowering the SORA rating?
I believe that my client will continue to litigate everything possible so that he can try to get out from underneath the commitment that he is in. I know that he has several notices of claims pending against people in the Department of Corrections. He has nothing pending, but has filed notice of claims. But I also think this issue is important for any defendant who is facing
but why does your client have a right to the procedural protections in this circumstance? Is it as the same importance as to any other?
I think so, because while he's in Department of Corrections, he maintains that he is being adversely affected by people in Department of Corrections based on his SORA level. And if his level was lower, that would give him a different position in Department of Corrections, who has access to his information and how he is treated.
His SORA level of level 3 was because of his prior felony conviction for a sex crime, correct?
Correct.
And so he would have been a presumptive level 3 in any event.
Correct.
And so I'm just getting back to the 2 documents that you say were missing, and I'm trying to understand how those 2 documents would make a difference to his modification, to his level. They would require reduction of his level based upon his background and what he's also been declared someone in need of supervision. He's confined under something. So I'm just a little confused about how these 2 documents would help.
Because we have no idea what's in those documents. It indicates in her letter that she reviewed them. She is not an attorney, so I don't know if she reviewed and relied upon them, but she indicates she reviewed them. We have no idea what's in it. It may be something that would be helpful to my client to defend his position, because in the modification, we have the burden of proof, and there may be something in there that was part of the basis for the board's decision. I understand his prior history, and I can't change what that is, but there may be something in those documents that he may.
Well, I'm suggesting, counsel, that whatever is in those documents, would those, whatever it is, would it overcome his presumptive level 3 rating because he has prior felony convictions for sex offenses, and he is he's in confinement. And beyond that, while he was confined, he's had a few instances of, problems. So I'm not sure what could possibly be in those documents.
And until we see what the documents are, it makes it hard for me to tell you how I would be able to apply those documents to his case. But there may be something in there that we could use because we have the burden of proof. I also feel that the case, as I indicated before, is important for any defendant doing a reclassification because it's our burden of proof, and therefore, if there's documents that are missing that the board relied on or reviewed, and then we don't know what they are.
The court didn't rely on them, did
the court did not,
never relied on
the court did not indicate it relied on it, but it is my.
You satisfied your initial burden because the court ordered them.
Correct, Your Honor.
Right? So the
Yes.
court granted you access to
Yes.
them. And it's not like the State opposed it.
No, there was no
It's just
opposition
there's a delay
whatsoever.
because of the location of the
Right,
document.
because it was in a remote storage
The question
location.
boils down to this adjournment request.
Yeah. In terms of, one of the issues in terms of when you're talking about an adjournment request, you have to look at the court's control of its schedule and calendar. I understand that. A lot of the cases that are cited deal when it's a jury trial. There's too many people involved, too much expense, too much going on. In terms of a SORA reclassification to adjourn it, it is the transport of the client back and forth from Department of Corrections or whatever location he is at. That is not a huge expense or a government expense in terms of this matter, versus on a jury trial when there's cases where someone wants an adjournment to go over some paperwork or a newspaper article, as the cases that have been cited. So I feel that it is not a huge burden on the government, and it's not a huge burden on the court to adjourn it for a future
Your
date.
client would have access to it on the next request, yes?
Right.
Or could demand it
Right.
again?
I believe that his attorney was providing him with everything as she received it. In terms of there's no
But
indication.
I'm saying a request for another reconsideration.
Yes, he can always request another modification, but I guess my position would be that we requested the documents, they weren't provided, it isn't a huge burden to have it adjourned for 2 weeks or so.
But did you make that specific request for 2 weeks, or did you make the request for whatever amount of time it would take to get the document?
The request specifically was for the amount of time to get the documents, but in the letter from Department of Corrections, it indicated it would take approximately 2 weeks. So that was where I got the time frame from.
Okay, counsel, you have your rebuttal time. Thanks.
Thank you, Your Honors. Good afternoon, and may it please the Court.
Counsel, what's so difficult of giving them the documents that they're entitled to?
Well, nobody had the documents, Your Honor. The judge did not have them, the people did not have them, and
So
defense did
why
not have
shouldn't
them.
they have them?
Well, it's not two responses to
Why
that.
shouldn't, well, if it takes a couple of weeks, it takes a couple of weeks.
That's a compound question, Your Honor, in
Go
that,
ahead.
okay, in that, one, should they have had them, and two, what about
Well, they're
an abuse?
entitled to them, aren't they?
I would hesitate to say automatically, Judge.
What does the law say?
Well, it's different than what the dissent said, because it doesn't apply the discovery within 168.0, and this is a reclassification, that's where the reclassification is not as broad as at the initial classification of 168N,
But the
which
question is whether or not due process requires more than what the statute. The statute may be in violation of due process. Isn't that what we've got to decide?
No, Your Honor, that was not brought up before this Court, whether or not due process
But
requires.
it was material relied on by the board. Isn't that the crux here? To follow up a little bit on that.
No, Your Honor, and
No?
no, because the
You
judge.
reviewed it.
So that's what so you say the dissent is incorrect in that then?
Certainly, Judge, and part of it is the discovery of them. But the board, and I don't mean to mince words, so I don't think this reviewed versus relied is even necessary, because as the judge pointed out in the initial questions, this is a presumptive override level 3. So even if we pretend those documents contain positive information, it would not defeat the presumptive override because of the two convictions. So there's no prejudice to whether the board reviewed, relied, whatever language we'd like to use. There's nothing in those documents that could defeat a presumptive override. Now, we
Why
want
did you
to
review them?
well, whether the board the board's review of that is as the court sees through the letters in 2010 from Don Amsler and the letter in 2012 from Mr. Weber at A1, the court sees that a lot of this important information goes beyond just the assessment itself. There's this nice information, certainly about this defendant's background since he made his modification petition. So I think that they review, I think the record supports that they review this information to place in their letter, but not actually
The concern, at least from my point of view, and it's been argued before, is that these things get treated really, really summarily. And maybe they should, maybe they shouldn't. But if the law provides that you're entitled to put this stuff before the court, then, as Judge Lippman said, what's the big – I mean, he's in. He's not going anywhere. And if it took you 6 months, get it in and get the record tight so that you can justify what's going on. Because he's going to be back. You know he is.
Certainly, Judge, and under 168.0, he could have been back the day after.
I know that, but you haven't answered my question. What's the big deal? I mean, I don't understand why the judge wouldn't say, call me when you get the records and I'll reschedule this hearing.
The standard is not whether another judge may have also one judge would grant an adjournment, one wouldn't. It's whether this judge's decision was an abuse of discretion.
Well, we're talking about due process. I mean, suppose the email is, regardless of what happens, we noticed this guy really didn't do the original crime, but we want to cover that up. So whatever you do, don't bring up the fact that he's innocent of the original charge. Now, I don't think that's what it says. But if it did, I would think it'd be material. And those things you get a little worried about. Sometimes.
Certainly not arguing that that information could have been material to defendant's argument. Our point here is at the 168.0 reclassification, where the proponent, the defendant in this case, has the burden of proof. 168.0 is not like under the initial assessment.
Let's assume for a minute that the Department of Corrections is part of the state of New York, which is the opponent to this person. So are they going to say, oh, my goodness, we better get this over there really, really quickly because we want to help this person who we're arguing against and who we hope stays with us for a very long time? The evidence is in the wrong hands. I'm surprised you even opposed this. I would have thought the DA would have said, let him.
I think it's clear from the record, and the record supports that we were just attempting to, after 2 years, we were back for this hearing. Mr. Lashway had his rights under 168 to have the hearing, and we were prepared to go forward. And in fact, as Your Honor sees, and as all Your Honors would see at that hearing, defendant was able to make all his arguments. And in fact, not just make the arguments within his modification petition, but was even allowed to go further and talk about his health, which was not contained within his initial motion.
If the shoe was on the other foot and your whole file was missing, and so he's making his pitch and you can't even remember what he got arrested for, and you ask for an adjournment to get the file from docs, would the judge be saying, hey, as far as I'm concerned, he's not even incarcerated, so I'm reducing it and I'm dismissing the SORA? You'd think that would be a denial of your due process.
We would certainly file under 168.0, which we have a right to do as well, and go forward at that time with the burden of clear and convincing evidence again, just as we had at the initial classification. And again, because it's important to notice that there could be information anywhere in the atmosphere or Department of Corrections or anything that might be material or relevant to Mr. Lashway. The purpose of 168.0 is not to reengage, relitigate, and to make the board and the people continue yearly.
That's true, but all he wants is access to what you yourselves looked at, and the court had ordered access to it. So again, we're back to sort of the circle is boiling down to not granting the adjournment so that they can have access to materials that you reviewed. Whether or not you discounted the value of these for your own decision is different from what the defendant may find in it. That's her point.
And again, I understand that through the state, the people represent the state. But to be clear, the record, the people, at least at the hearing, did not have those emails, and the court did not have those emails. But
I understand the
court.
court.
The day before, right? You got a response the day before. May 7th was the date that you got the response. It was the day before the hearing.
I believe it was sent May 3rd. The response was given to the judge May 2nd from the board. May 3rd, it was sent to the parties. Both parties are within very close proximity.
So just to clarify, you never reviewed them?
No.
And you never said you reviewed them?
No, those emails? No,
Correct.
I've never seen those.
There's a saying they were reviewed, or that is of no matter. That is incorrect. Factually incorrect.
Yes, Judge. The record is completely different. There's no information. The people never had them, and the judge never had them. If we had them in our hands, we would have given them. And the record does support later on, ADA Padula, who was handling the matter, discusses with the court that everything that we did have that day, which was the RIA, RAI assessment, the presumptive override, and the PSI, we made a copy of that and provided it to defense. If we had those emails, we would have handed them over.
So it just boils down to whether it was an abuse not to grant the adjournment.
Absolutely, Your Honor. And while I won't stand here and say that reasonable minds might disagree, it certainly would require this court, a reversal, would require this court to find as a matter of law that this was an abuse of discretion. And this record and these facts simply do not support that.
Okay, counsel.
Thank you, Your Honor.
Counsel. Rebuttal, counsel.
Thank you. I would respectfully request that the court overturn the decision and return the case back. Thank you very much.
Thank you both. Appreciate it.